This video is for you to help you a little bit with FE1 exams. I hope you will like it. And I want to start with contracts. But first of all, maybe I would tell you a little bit general tips in relation to those exams. So topics are mixed. There will be very rarely a single issue in a question, at least two topics in one problem question. So you can't rely that you will have one single problem in one question. So the best idea would be to learn or to have a kind of knowledge, a kind of shallow knowledge of all the topics. That would be the best. And of course, I would focus on. I will tell you which topics occur the most in those exams. So then you can mostly focus on them, but you should know everything. Yeah, like you should know more or less. I hope that you know what I mean. Okay, so this is what I wanted to say, and then yes, and then in relation to examiner feedback, people fail to identify and discuss the relevant issues. So this is very important that you are certain that this is the answer to the question, and you should stick to the point. And for example, like if you know about this question and about this topic, but you know in general, or you know different answer, don't give different answer. Just you should stick to the question. And then in relation to contracts, contract law, I would pay attention to every sentence, because it means, like they might expect, you to notice, and this is good attention to details as well, so you should pay attention to every single sentence in the question. Okay, next one. Yes, so again, this is examiner feedback, that people write too much irrelevant material. So if you know a lot about this, about a certain topic, don't, as we say, puke out everything what you know, because it would be considered as irrelevant, and then you will lose points because of it. Then people fail to mention relevant legal authority. So this is fundamental, that if you answering the question, you need to remember the case law, and it's good to know a little bit the facts of the case, and of course the names of the cases, and to provide that in your answer. And another issue that this is another feedback, is that people fail to apply the law to the facts of the problem questions. So once you stick to the point, then you choose carefully which case law would match to answer this question, And then once you say about this case, then you should say applying this and that to our present scenario. This is what I was saying. I'd say this and that. So you should try to find either differences or similarities to the questions in your answer. Okay, next one. Yes, and you should remember that there are 8 questions and you should approach 5 questions. And when I attended the courses to prepare me for these exams, every single lecturer said that it is important that you attempt 5 questions. And in relation to contracts law, when I started writing the exam, I checked the questions very quickly and I was like, okay, yeah, I don't know that. So I thought that I would fail, and then I attempted first question and I focused, and of course I chose the question that I knew the best. I focused on answering that question, and then I thought, oh yeah, it was good. Then I read another question. I was like, oh yeah, I know the answer to the second one. So I answered the second one, then the third one, and the fourth one, and I started being really happy. I was like, oh yeah, I thought that I didn't do so well, and like it was working fine. But then I started having like serious problems with the 5th question because I had a rough idea what I was talking about. I think that maybe I gave 1 or 2 case law to that answer. So I thought that I would probably fail because of the last question, but I attempted it and I passed that. So this is vital that you would attempt and you need to answer 5 questions. And this is very important, and I noticed that some people had watches and they divided, like, for to read the exam very carefully you would need maybe like 10 or 15 minutes, and it's well spent, so to speak, because you need to know which questions would be the best for you. And then around 30 or 35 minutes you should have to answer certain questions. So then, if you have more to say than that, it would be the best to try and answer another question and then another one. And then when you have time left, then you should go back and finish those questions. Okay, next one. Yes, so examiner feedback is that sometimes some people rely on standard notes or some study guides, which is not complete and it's inaccurate. So once you're studying, you should make sure that everything that you're studying is up to date, because this is very, very important. Okay, so in relation to contract law, I would study. So of course you can take my advice, and it's up to you if you take it. But I would study offer and acceptance. I would study consumer protection. remedies, consideration, mistake, misrepresentation, contractual terms, and one, just bear with me 2 seconds, I can see that, exemption clauses. So I would focus on this, and then of course, you know, once and my approach was to study, for example, these topics like a lot, and to know them like really well, and then to add some other things, you know, some other topics, and have a kind of rough idea about it. But again, if you're studying a lot, and if you're learning by heart, then your brain gets used to this. And then, you know, to remember another, I don't know, like another 10 or, you know, additional 10 or 20 cases, it wouldn't make a huge difference. At least, you know, I was, you know, that kind of way. Okay, next one. Yes, so you have, in relation to contract law, you have 2 pieces of legislation permitted during the exam. This is Sale of Goods Act 1893 and Sale of Goods and Supply of Services Act 1980. So you should order this, and you can't write anything on that. I think that you can highlight some parts, but make sure that you can actually do that. Okay. Yes. So in relation to answering the questions, the structure is vital. The structure of your answer. And probably some of you know ILAC. So this is I for issue. So the basic method, but this is like basic method of answering a question would be the issue in this question is this and that. Then L. So law, so then you would say, you know, either legislation or case law, and then application. So you can say like applying law to this question, or I would apply, or applying, you know, and then the name of the case law. You know, and then you would say applying, for example, Harvard Law investment in this, and then, you know, like find similarities to your answer, and then C, conclusion. So the structure. Again, the structure of your answer should be, you know, the opening paragraph should be the issue. Then in the middle you should have case law. You should have application of the case law, and then you should have conclusion. And sometimes when you have 2 topics in one question, or 2 issues or 3 issues, for each of them you should apply this structure. So issue, law, application, conclusion, and then conclusion at the end as well. And then what I wanted to say, it slipped my mind. It was in relation to structure. Yeah, I don't know. Probably it wasn't that important if I forgot. Okay, maybe I will remember later on, hopefully. Yes. What else? Yes, so in relation to contract law, the structure, and then once you approach the question, you should know if this is and if we are at the beginning or in the middle or at the end of the contract law. Just bear with me 2 seconds, maybe I will move it a little bit. Yes. Okay. Yes, so the a kind of the beginning would be offer and acceptance, consideration, promissory estoppel, statute of frauds, intention to create legal relations. Then the middle would be terms, consumer protection, exemption clauses. And then the end, or yeah, like, you know, the third part would be mistake, duress, undue influence, illegal contracts, void contracts, misrepresentation, discharge, and remedies. Okay. Okay, so we have offer. The terms of the offer must be clear, certain, and complete. The offer must be communicated to the other party. Offer must be made by written or spoken words, or be inferred from the conduct of the parties. The offer must be intended as such before a contract can arise. Okay, and in relation to the case law, I will discuss a little bit some case law. It might not be sufficient, so I would suggest that you would add some case law to what I will be discussing. I just want to give you a kind of general idea, and maybe I will help you a little bit with with understanding of this. But I would definitely learn more case law than I will be discussing over here. Yes, and another point that I would like to make is, for example, once you're, and sorry that I'm just interrupting, but I just thought about this right now. When I was studying, I was doing few kind of approaches, because I was studying from the notes, I was studying from the book. Then I attended prep courses, which I thought were really, really good. And for example, every day when I was going to work and I was preparing breakfast, preparing for work, I was listening to the lectures. Then another thing which I did was I recorded myself when I was reading. So, for example, when I was reading the name of the cases, I repeated that 3 times because I wanted that to stick in my mind. So, for example, over here we have, I hope that my pronunciation is okay, Leonard versus PepsiCo. So I would repeat that 3 times: Leonard versus PepsiCo, Leonard versus PepsiCo, and then I would read the facts, and then conclusions that we can draw from this case. So many different approaches helped me. So the more techniques to remember the material, the better. This is my opinion, and of course, you can take it or you cannot take it, whatever you think. But it was my approach, and it worked. So over here, in relation to Leonard versus PepsiCo, there was the ad with a catalog, and then you should get the points, and then if you got the points, you would win. You would get the jet. So the conclusions are like that. It was invitation to treat. It was advertised in POF, and you couldn't expect that somebody expected to get the jet. So it was the conclusion in that case. Yes, and then when you are answering the question, you should use more sophisticated language. So in relation to offer, you should use offerer and offeree. Offerer is the person who makes the offer. Offeree is the person to whom the offer is made. So we have bilateral offer, which is accepted by promise to do something. Once accepted, both parties have assumed obligations under the resultant contract. There can be a promise in exchange for a promise. So both parties make a promise. So I promise you to pay 300 euro if you, or 2,000 euro if you promise to sell me the car or the book, for example, for 100 euro. There can be a unilateral offer, which is accepted by performance of act, forbearance from acting. So once accepted, only one party has assumed an obligation. So the best in relation to unilateral offer would be, the best example would be the case law, Hammer versus Sideway, when the uncle promised nephew 5,000 if he abstained from drinking liquor, using tobacco, swearing and playing cards. And then it was enforceable, because if the uncle offered that he would pay that amount of money, and then nephew accepted it by his conduct, that he did what was required, then he accepted the offer and he was entitled to the money. Another very quite popular case is Carrill versus Carbolic Smoke Ball Company. This was £100 to anyone who contracted influenza after using the carbolic smoke ball. So it was unilateral offer, and once accepted, so the person accepted the offer, he contracted influenza, and then he was entitled to £100. This is British case, 1893. And then we should know the difference between offer and invitation to treat. So invitation to treat, to treat would be a display of goods, for example, on the shelves of the shops, or the display in the display windows. So this is an invitation to treat. Popular case in that regard would be Minister for Industry and Commerce versus PIM. This is shop display. Another case would be Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Then we have MIE inquiries. It would be Stevenson, Jacks and Company versus MacLean. Quotation, Harvey versus Pacey. I hope that this is the right pronunciation. Sometimes there might be a question in relation to lotteries. So it would be advisable to learn Carroll versus Ampo's National Lottery and Horan versus O'Reilly and others. These are the cases if the question in relation to lotteries would appear. Termination of an offer. Rejection, revocation, lapse of time, death. Rejection. Once the person to whom the offer is made chooses to reject it, then the offer is terminated. There is something like the battle of the forms. So it refers to the communication between the parties. So the questions which might arise during the process. Revocation. Revocation usually arises when the person who made the offer wishes to withdraw it. And very important that the offer can be withdrawn anytime before it is accepted. Conditionally, that no consideration has been given. And we will discuss consideration later on. So the cases that you should pay attention to would be Dickinson and Dodds, Walker versus Glass, Errington versus Errington. The facts of the case in Errington versus Errington is Errington bought a house, partly for cash and partly with a mortgage. He told his son and daughter-in-law that the house will be theirs if they pay the mortgage. So they were paying the mortgage. Then the son moved out and daughter-in-law kept paying the mortgage. And then the issue arose after Errington's death because he gave the house to his wife in a will. And it was held that it was unilateral contract, which was completed by performance. the offer could not be revoked once couple entered on performance of the act, but it would cease to bind him if they left it incomplete and unperformed. So this is the conclusion from this case. Lapse of time, it will depend from case to case. So it will generally terminate upon the lapse of a reasonable period of time. But as I said, it will depend, it will vary from case to case. And the last one is death. Thank you very much for watching me. I hope that it's helpful. If you like it, and if I have time, I will put more videos, and I will continue. This is my first video that I'm recording for my channel. I hope you like it, and thank you very much for watching me. Bye!